I'm back relegated where I have to stand right in the middle of this room because there are people streaming. So if I move away, then they can't say anything. Anyway, my name's Katie Radis. I think I know just about everybody here. And I want to congratulate you all for coming to the mid-year legal update, trying to find that sort of ever-moving target of where the law is and what you actually have to do as a California employer. Before I get into this, though, some quick housekeeping. If you need to use the restroom, it's straight through here. And then hopefully there was enough parking and you didn't park along this side back here. If you did, they sometimes get mad and then your car might not be there when you go out. I'm going to touch on, before I get into what's actually here, what's not in this update. And what's not in here, in the interests of not bombarding you with thousands of pages of documents, is everything that we talked about in January. Okay, so that was a lot of the new laws that went into effect January 1 of 2013, a lot of the big cases that we saw over the past year from 2012. So that stuff is not in here. If you weren't able to attend that update, or if you want that information, just, you've got my phone number or my email, just give me a buzz. I'll shoot you. I've got lots and lots of these updates. I can go back 5-6 years if you want. At any rate, there's just simply too much information. At some point, you know, if I gave you everything, your eyes would glaze over and then you'd never come back here. So the materials are divided up. First, a legislative update and then a case law update. The legislative part of that is these are the new laws, okay? Either new laws that we're looking at happening, new laws that have just become effective, or in some cases, new laws that are not going to be effective. And then the second half of the material is the case law. And the cases are organized by topic. So, you know, hiring issues or leave of absence issues. So we're going to get through as much of this as we can. We wanted to take a little bit of time to walk through that HRIS system since we have, this is a closed session just for clients, as opposed to our, you know, we don't really want to walk through all that kind of stuff when we have an open to the general public group. So anyway, that kind of condenses our time a little bit. We have allowed, I think, an extra 30 minutes for this session, but if people need to go back at 1, I certainly understand. So anyway. All right, I'm going to dive right in. The first thing we have, the Affordable Care Act. We finally got some good news. Usually the term good news and Affordable Care Act aren't in the same sentence, but in this case, they are. And that's because we got a reprieve. There's been a 1-year extension on the employer obligations in terms of reporting and in terms of imposing those penalties for failing to report and for failing to provide the health care. There's the regulations, and you may remember in January I talked a little bit about the proposed regulations. Those proposed regulations went up, and there's been a big comment period, and now we have final regulations. Only after the final regulations came out, they said, well, we're going to wait to enforce this because there's too many problems and issues with this. It's not clear, you know, what you actually have to report or who has to report or how they quantify that. And so in light of the fact that no one really knew what to do, they said, well, we're just going to wait for a year. And in this year, we're going to hopefully figure out what it is we need to do. Okay? So I don't have a lot of answers. I'm getting a lot of questions, but what does this mean? I know there are certain provisions of the Affordable Care Act that are still going into effect. If, you know, that 90-day waiting period, you can't have somebody wait more than 90 days to come onto your health plan, things like that. Hopefully, and by the end of the summer, we're supposed to have the interim regulations that tell us how we move through this sort of transition year. So hopefully around September we have a little more information. Certainly that's going to be a topic that we would probably do a lunch and learn on, and as more information becomes available. But we're in a little bit of this sort of wait and see mode at the moment. You know, but I'll take wait and see over you're about to get hit with, you know, $3,000 penalties for each employee. So that's where we're at with that. The new I-9 form, hopefully everybody's using the new form. Okay, it's sort of a longer format. It's 2 pages now. They made some other changes, and that needed to be in effect as of May 7th. So hopefully everybody's got that new form. If you don't, just let me know. I can make sure you get that. Itemized wage statements for temporary service employers. This was a law that actually was enacted as of January 1, but it didn't become effective until July 1 of this year. So if you're a temporary service employer, temp agency, okay, you need to have modified your wage statement so that it includes new information. There's also an obligation to provide some changes on that wage theft notice. And that wage theft notice is the notice you give to new hires or you give to people whenever their wages change, and it outlines your workers' comp carrier and their rate of pay and all sorts of extra stuff. Okay, that was a new one as of 2012. Human trafficking. Okay, that as of April 1, you need to have that human trafficking poster up. You can get the poster through Cal Chamber. It's available. Not everybody has to post the human trafficking. Okay, there are certain industries, I think they're listed in here, people with alcoholic beverage licenses, adult or sexually oriented businesses, airports, bus stations, truck stops, things like that. Okay, if you're not on that list, don't worry, you don't need to put it up. It's probably, not going to do any harm to put it up, but they're targeting industries where human trafficking seems to occur. The NLRB posting. Some of you may remember this. The NLRB came out about a year and a half ago, I think, with a rule saying every employer needs to post this big notice that says you have a right to unionize and blah, blah, blah. These are all your rights under the National Labor Relations Act. Okay, big outcry from employers. We've got enough stuff that we need to post, and nobody wanted to post this because, of course, no one wants unions in their workplace. So there was a backlash against this, and it was halted by court order. That court decision, and it's in Washington, D.C., it's a district court, and they decided, look, the NLRB totally exceeded their authority. They do not have the right to require employers to do this. That was sort of on hold because there was another court looking at that issue as well in the Fourth Circuit. That court just issued their decision last week and said, same thing, this is a gross, exceeding of authority, and employers do not need to post that. I'd like to tell you that that's the end of the NLRB posting requirement, but I suspect that they will appeal those decisions, or at some point they're going to probably have to withdraw that rule. It's still on the books for now, but you have no obligation to post that for now. And then finally, we have a big HIPAA final rule that was published. If anybody has insomnia, you can pick up the HIPAA Omnibus final rule and cure yourself. It honestly is like half the length of War and Peace. It's just beyond tedious and slow. So I'm not going to spend a lot of time on that. What this really goes through are those breach notification requirements. When do you have to inform somebody? What do you have to tell them? And that sort of thing. If you have issues about personal health information and concerns about this, it's something that you're going to want to look at. There are different areas that synthesize this information, so you don't actually have to, thumb through thousands of pages of regulations. Okay, so that's the very brief, in a nutshell, legislative part of this. Are there questions about any of this? All right, I want to dive into the cases just so that we can get through as many of these as we can. This first one, Glatt v. Fox Searchlight. You may remember, I think, in 2010, we had a letter from the Labor Commissioner that said, hey, we're going to loosen the standards on unpaid interns. California had like 15 factors that you need to satisfy before you could have somebody classified as an unpaid intern. And in 2010, they said, well, we're going to get rid of that California test, and we're going to go with the federal test. And the federal test is a little bit more lenient. There are certain things you still need to do, but it's like most things, in California, the state law is a lot more stringent. So we're going to go with the federal standard. Okay, so what happens after that letter comes out? Of course, everybody says, great, you're now an unpaid intern. And they start bringing in these interns in huge numbers. We've started to see these cases come up now of, by the way, I'm not an intern, I actually want some pay, I'm an employee. This is an example of one of those cases. And these were interns at Fox. They made coffee, they made copies, okay, and they were told that they were unpaid interns, okay, and that was all fine and good. They agreed to that until they got mad and filed a lawsuit, and lo and behold, no, they're not unpaid interns, they're employees. One of the things I want to highlight about this decision is that these interns went into that relationship understanding that they weren't going to get paid. Okay, they agreed to it. This is an internship program. There's no pay. You come here, you get to work with Fox executives and you bring coffee. Okay, even though they had agreed to that, even though that was the understanding, it still wasn't okay by the courts. And it's a good example of those provisions in the labor code that you can't contract around. Okay, one of them is minimum wage. All right, it's the same sort of situation when you have a person who says, well, I want to be an independent contractor. And the employer says, well, I want you to be an independent contractor. Even if you agree and write a contract out and everyone's happy and thrilled, that doesn't necessarily make it so. Okay, there are provisions that you can't create a contract around If we wrote a contract that, the sky is pink and you agree and I agree and we sign off, that doesn't make the sky pink. It's still blue. This person's still an employee, whether they agree to it or not. Okay? Yeah, Joyce.
A lot of your private colleges, like SUC and programs, they have external programs.
Yeah. Well, and the question, just for the people who are streaming, there are a lot of universities, schools that have extern programs. And the key there, and what was missing in this Fox situation, is that there's a benefit to that employee. If they get something, akin to college units or college credits, or there's some benefit to them, then the internship will likely stand. And that's why you get a lot of nursing programs and things like that have this sort of exchange where you can do an internship. Okay, and what they're really trying to distinguish between is something where they're getting some sort of educational credit for this versus somebody who is doing menial labor and you just don't really want to pay them, So, and that's like anything else. We get it, you get a little bit of leeway, and some people take advantage of it, and those people who take advantage of it ruin it for everybody else. So now we've really got interns under the microscope. So if you're using them, just make sure you go through what you need to show. And I can get you a copy of that fact sheet that outlines particularly what needs to be there. But yeah, it was a good question. Okay, other questions about that one? I'm going to jump down here to this in the news section, the OFCCP. It's a sort of a new body. It's actually not a new agency, but it's just started to become active in employee enforcement things. You used to get those like a notice of a charge from the EEOC. You may start getting them from the OFCCP as well. They've started enforcing disparate impact discrimination claims. They issued some guidance with respect to the use of criminal background checks. Okay, and I want to highlight this just because this is an area that is really getting a lot of focus. If you use criminal background checks, okay, make sure that you follow those best practice guidelines. Make sure that it's job related, consistent with business necessity, that you're doing an analysis to make sure that you aren't weeding out any one group more so than another. They start with the presumption that if you're using a criminal background check, you are disproportionately impacting minorities. That's the starting point that they start with. So it's your job to overcome that hurdle. So just be very, very careful. I'm not saying that criminal background checks aren't appropriate and aren't something that you should do. You just need to make sure you don't back yourself into a lawsuit by using them. Okay, and if you want to do background checks and things like that, I typically advise that you use a third party to do that sort of screening. There are lots of companies that provide that service. It can insulate you from the liability. It gives you the defense of, hey, I didn't know about any of that. So it can really be a lifesaver, especially when it's a topic that's getting such close scrutiny. All right, that's the hiring stuff. I'm going to move into wage and hour unless there's other hiring questions. This first one, Choate, is kind of an interesting argument. In California, there's no such thing as a use it or lose it vacation policy. Okay, when somebody accrues vacation, that's considered deferred wages. That you don't get to take it away from them. All right, but there's an exception to that if there's a valid collective bargaining agreement, because typically vacation is something that the unions like to negotiate. So if you've got a collective bargaining agreement and it says something different, i.e. you don't need to pay the vacation, then that's going to be okay. In this case, the agreement said you have to pay them whatever vacation allotment is due at termination. Okay, and they had this accrual thing where you accrued over the course of the year based on seniority and how long you'd worked and so forth. Okay, and so the person gets terminated in March of 2007, and so they were paid all their vacation up for the previous year, but they weren't paid anything, that pro rata share for the vacation they were accruing towards the 2008 allotment. Okay, and so the court looked at that collective bargaining exception. And what they said was, unless that exception says specifically they're waiving their rights under Labor Code 227.3, or unless it specifically spells out you are not going to get your pro rata share of vacation, it's not going to be considered a valid waiver. Okay, and which means potentially for those of you who have a collective bargaining agreement or have a union in place and there's language in there about that vacation pay, you're going to want to go back and take a look at it, okay, because you may have an issue potentially of people trying to come back and make claims on that. Okay, remember wage claims go back 3 years, so that's something you're going to want to take a look at. When I do the legal update, I wish I could only give it to the employers and the defense counsel. Okay, but The plaintiff's lawyers also get to see the update. They're also up to date on what happens. And when you have a case that is successful and the plaintiff wins, all the other plaintiff lawyers go, hey, that's what we want to file. That's the claim we want to raise. And so that's why we tend to see a flood of litigation after we have a new issue that gets decided. So particularly if you've got a CBA, you're going to want to take a look at that. Falconberry v. Boyd is a good example of how we're going to see those meal and rest class actions proceed after Brinker. Remember, Brinker was the big decision we had a couple years ago. Says you don't need to actually ensure the meal period is taken, you just have to give them an opportunity to take the meal period. Okay, the way the court analyzed that case was really good in terms of class actions, because they basically said, look, if you have to look individually at each person to see, did you take a meal break, could you take the meal break, this isn't appropriate for as a class action claim. Okay, and we've seen really a big decline in those meal and rest class actions since then. What this case said was, well, if you have a uniform policy that applies to everybody that violates the meal and rest law, well, then you can still have a class action for meal and rest violations, okay? Because everyone's going to be subject to that policy the same way. Okay, the lesson, make sure, go back, look at your handbook, make sure it clearly states you have an opportunity to take that meal period. Make sure that the tacit, understood policy at the workplace is everybody has the opportunity to take a meal break. Okay, if there's an argument as to whether or not your policy, whether it's the operational reality or whether it's the written policy, if there's a question as to whether or not that actual policy violates the law, you may still be open to a class action. Okay, and those, I don't need to tell you guys how expensive that stuff gets, because you check on penalties and waiting time penalties and wage statement violations and blah, blah, blah. It just really, really adds up. Green v. Bank of America. This is remember the seatable suiting cases? This started about 2009 or 2010. There was a big case against 99-cent only. And they said, hey, the wage order said the employer has to provide seatable suits if it's, reasonable in light of our job or something along those lines. There's a paragraph of the wage orders, I think it's paragraph 13 or 14, that specifically says you need to provide seatable suits or suitable seating, seatable suits. You need to provide suitable seats for employees. So what we have were a lot of these cashiers, bank tellers, saying, hey, when it's slow at the bank, I want to be able to sit down, and there's no seat here for me. I think there'd been something like 250 claims filed since that first 99-cent only case. The only one to go to trial so far was Garvey v. Kmart, and the court said, well, in order to put a chair in this checkout stand, they were going to have to remodel and reconfigure every single checkout stand, and that was not reasonable. And they said, okay, Kmart did not need to restructure their every single store in order to accommodate seats. They did say that, well, maybe they could have a little stool that they could lean on, and that might work. And so it kind of left the door open a little bit. In this case, which is the Bank of America, these are the tellers. This claim had come up, and the lower court said, well, you don't get to complain about not having seats because you never asked for a seat. If you would have asked for a seat, and then they said, no, that's one thing. But this went up, and the Ninth Circuit said that, there's nothing in the wage order that says employee needs to request seats. It just says employer needs to provide seats. So they revived the claim, and it's going back to court, and we'll see what they say. Again, what they really did was sort of take away one of those little defenses that we had. This is one of those cases that the plaintiff's bar is watching closely, okay? Because if they win here, again, you're going to see that new influx of cases. So, and I've said this from the beginning, a lot cheaper, go to IKEA, buy a stool for $10, okay? Certainly, if you've got a space that's big enough to permit a chair or a stool, it would probably be a wise idea. But again, that's one we've got to watch. I'm going to skip over Ecolab. That basically said if you're a pest control company, you've got people that are carrying small quantities of hazardous substances, they're not going to qualify for the hazmat exception. This one at the top, Negri, is kind of a clever argument. In order to be exempt under state law, you need to be performing exempt duties for more than 50% of the time, but there's also a salary requirement. You need to make a salary that's no less than 2 times minimum wage. What they argued here was, well, technically his pay was based on an hourly rate, but he was always assigned the exact number of hours. So, he got the same exact amount every single payroll, and that's the same as getting a salary. He knew he was going to get this. He knew the hours were assigned. He always knew the exact amount, and that was tantamount to being paid a salary because it never changed, it never varied. And the court said, clever, but no. If it's based on an hourly rate, if it's based on tasks they perform on a piece rate, it's not going to be a salary. Okay? It was a nice try, but it just didn't work. Down at the bottom, the numbers don't lie. Okay? The labor commissioner, this is just the California labor commissioner, 2012, their numbers are in $51 million in civil penalties against California businesses. Okay? They are really hitting it hard to California employers. This is a big increase. I think 150% since 2010. So more than ever, it's really important to make sure you're in compliance, and it's these little sort of picky, pesky little things that tend to get employers in trouble, all right? And unfortunately, the shucks, we missed that one, defense doesn't really work. On the next page, this is another study. This looked at the average settlements, okay? And the average settlement is up to $4.8 million for 2012. This is nationwide, okay? And this, but of course, the bulk of those are coming from California and New York, where most of these claims are filed. California, New York, Massachusetts a little bit as well, by far the most employee protection. So that's why we see most of these claims get filed here. The good news in all of this is that we have seen a big decline in the class actions. Okay, those numbers will probably come down as those class action claims start to go away, because that's where we tend to see the bigger dollar amounts. And particularly in California, a big decline in the meal and rest class actions. That closes out the wage and hour part. Are there other questions about any of this? All right. Leave of absence. Lineberry, this is kind of an interesting one. It's not a California case, but the court was looking at the Family and Medical Leave Act, the FMLA, which applies in California as well. And it's kind of a good case for employers. She went out on it, she got hurt. She was a nurse and was moving stretchers. She hurt her back, so she went out on an FMLA leave. While she was out on leave, she had a vacation to Mexico that was already planned. So she goes on her Mexican vacation, and because she's on vacation, she's posting pictures all over Facebook of her on a motorcycle, and she's out shopping, and she's drinking beers, and she's whatever. Woo! Okay. Her coworkers, who are, picking up the slack for her because she's out on medical leave, are looking at all these Facebook pictures thinking, give me a break. And so they told management. Management called her in when she got back from her leave, and and they said, well, did you really need to be out on medical leave? And at first she lied about it, and she said, oh no, I used a wheelchair the whole time during my vacation. And they said, well, we're going to get this. They threatened to get the security cameras from the airport and, pull up all these pictures. Anyway, then she said, oh yeah, I was just kidding. I did not use a wheelchair during my trip. Anyway, and they terminated her based on their belief that she had lied about the need for FMLA. And the court said that was fine. If you have an honest belief that the employee has lied or tried to misuse those leave rights, then that's a terminable offense. Again, it's not a California decision, but it's certainly helpful, and I think lends a lot of credence to employers who want to take action for people when they're posting stuff online, or when you hear word of mouth, oh, guess what? They weren't disabled after all, Along those lines, you can do a sub rosa investigation. If you have somebody that's out on disability and you don't think that they're actually disabled, there are ways you can monitor that and investigate that. This next one, Olafson, another sort of interesting issue. He told his employer that, hey, I need leave. My mom's having surgery in Sweden, and I need to go and help her after her surgery. So he tells the plant manager, and the manager says, okay, yeah, well, you can take leave, but you need to fill out these forms, and we need to train somebody to do what you're doing while you're gone. So great, okay. He gets the forms from HR, he fills them out. In the box where it says, are you eligible for FMLA, he checks yes, because the plant manager told him, yeah, you can take leave. And then he goes about training the new replacement. While he's training the replacement, I think that took place over a 2-week period. he still needed to get the medical certification in. It took a little longer because the certifications were coming from Sweden and so forth. At any rate, the paperwork comes in and he goes out on his leave. While he's out on his leave, the HR department finally discovers that, oh shucks, he has not worked the required 1,250 hours. So guess what? He's actually not eligible for FMLA leave. Okay, and so they call him up, hey, you know, we realize you're in Sweden, but guess what? You're not eligible for FMLA leave. You need to come back and report to work. And if you don't come back, we're going to fire you for being absent when you're not supposed to. Okay, he didn't come back. When he finally did, they fired him, and they said you were not out on a protected leave. And he sued, and he said, look, when the plant manager says to me, yeah, you can take the leave, that was the same as approving the leave. And when you had me train for 2 weeks somebody else to do my job, that was tantamount to saying, yes, we understand and approve and agree that you're going on leave. Okay? And the court said, no. Inactivity, silence does not necessarily mean that you've approved that leave. Okay? They allowed them to terminate him for failing to come back. The leave didn't, wasn't any good. The one little sort of word of caution I will give you from this case is that, it took that HR department, upwards of 2 weeks to decide whether or not he was eligible for the leave. Okay? That's too long. I mean, they sort of dodged a bullet there because they could have easily said, look, you need to respond in a more timely fashion. Had they told him that he wasn't eligible for the leave before he left, it would have been a lot easier, presumably, for him to get back. Even so, that wasn't enough to, to make the employee win in this case, but it's a little sort of reminder, make sure you're on top of that process, okay? Make sure you go back and this isn't something that goes onto the back burner, okay? Yeah, Sylvia.
Would that also dismiss that maybe this employee, what if the employee asked for money back from his plane tickets or something, just the fact that he was dismissed, would dismiss the whole thing?
Yeah, well, the question is, could he ask for money back and whatever? Yeah, I suppose he possibly could have. I don't know. That didn't come up in this. Then you're getting into sort of that reliance damage. Hey, I relied on the assumption that you would approve this and so forth. I think in that case, because he didn't change his plans, he stayed and did what he wanted and then came back. So I don't think he would have any damages in that case. But you might open yourself up to a claim along those lines if you have somebody that is operating under an assumption that you later discover to be false. If the reason that they went along for that much time on that assumption is because you delayed and dropped the ball and didn't get, then you might have a problem. Yeah.
Because I had a case once when something had happened, everybody thought I had worked the time and he didn't.
Mm-hmm.
And he was told like Tuesday, he said, no, you were not eligible after that. And he said, well, okay, I don't want to use my job, but you have to pay me back $2,000 with the ticket. And
Yeah.
he was supposed to go to court. I don't know what happened. But
Yeah, that's interesting. I haven't really looked into that issue much, but it doesn't surprise me. I mean, if you've got, and I kind of think, remember when they go to court, they're going to a California court where the laws, are really on the side of the employee. If you've got a little employee who says, I thought I could take this leave, I was trying to help my mother, in front of a jury, that doesn't play very well when the employer says, oh, well, we waited for 4 weeks to tell him, and in that 4 weeks he bought his plane ticket and he relocated, whatever the case may be. So I think you're fighting an uphill battle trying to win that claim. And truthfully, that's something that can be avoided if you just manage this process carefully. When that request comes in, send it in, sit down, look, it shouldn't have taken 2 weeks to figure out the guy had not worked 1,250 hours. Okay, there should be some of those basic parameters. Are there, more than 50 employees within a 75-mile radius? All those requirements for the FMLA to even get triggered. That stuff shouldn't be stuff that's very difficult to figure out. If you've got a huge volume of business and, you're getting 50 requests a day, okay, then I can understand how it may take some time. But that's also not going to be a defense in, oh, shucks, we just didn't get around to it. So it's a good case for employers, but I don't want the takeaway lesson to be, great, we can tell everybody 3 weeks later that they don't qualify for FMLA. The next case on the next page, Proc v. Chimera, this is another one, sort of a good reminder for employers. She went out on pregnancy disability and her 4 months expired and she was not able to come back. And so they said, I'm sorry, you've used up your 4 months of protected leave. And so they fired her. And she said, wait a minute, I'm disabled. Nobody engaged in the interactive dialogue. Nobody talked to me about accommodations. And they argued, hey, our obligation is to provide this amount of leave. And that's what we did. And when that leave ended, our duty to her ended. We no longer had to keep that position open for her. While that's true, what the court said was, you don't get to just terminate somebody the day that the leave expires. They then fall under the Fair Employment and Housing Act and the Americans with Disabilities Act, and that's when you start that interactive dialogue. Okay? When we talk about the interactive dialogue process, that's that conversation between the employer and the employee as to whether or not there might be some accommodation that would allow them to return to work and perform their essential job duties. The employer has to begin that process. Hey, we have reason to think you might be suffering from a disability or from some condition that is preventing you from performing your essential job duties. Remember, one of your essential job duties is coming to work. Okay, can you please contact us so that we can discuss whether or not there might be an accommodation that would allow you to, perform your job duties, return to work, and so forth. Puts the ball back in their court. They need to contact you. It's the employee's obligation to come up with the accommodation. Okay, they need to come up with the things, hey, maybe I could do this, maybe I could telecommute, maybe I could, sleep in every day, Just because they suggest something doesn't mean you have to do it, all right? But it's their obligation to come forward, and it's your obligation to consider it, all right? You only need to provide accommodations that are reasonable, okay? And when we decide what's reasonable, we're gonna look at the nature of your business, how many employees do you have, and all those sorts of things. What's this person doing? And this is this sort of individualized assessment. Okay, but the key is you don't get to fire them, the day that they're supposed to come back and don't. That's sort of like the end of the leave sort of is the beginning of where your obligations start in terms of that interactive dialogue process. Okay, and I get those questions a lot, well, she can't come back and her leave expired on Thursday, so can we fire her on Friday? No, probably not. Let's talk to her about, what we can do to get her back. Okay, you don't have to, and this case doesn't mean that, you have to extend that leave out forever, all right? You don't need to make a temporary leave, a permanent thing for this person, but you just need to consider the different options that might be available. There's a couple questions. Yeah, Sylvia.
What if you have a case when the person who went to the FMLA for pregnancy disability, that was the person who didn't want to deal with any accommodation, that's the person that pushed through the doctor by a job description and convinced the doctor that it was no way they can do any accommodations and she cannot take any light duty. What do you do in that case?
Well, if the person comes back and if the person goes out on leave and then the leave is up and you say, okay, you need to come back to work, and they say, I absolutely can't do anything, I'm totally disabled and I'm not able to return, at that point you say, okay, well, let's engage in this dialogue. Is there something that we can do that might enable you to return to work? Would an additional, 2-week leave, make it such that you can return to work? Is that reasonable in light of your business and so forth? At some point, granting leave, it's no longer reasonable, because if the additional leave isn't going to do something that helps them to come back to work, then it's not enabling them, it's not really an accommodation. For example, if I become paralyzed, okay, and I need to walk as part of my job, it doesn't matter how much leave you give me, it's never going to accommodate me and enable me to come back to work, okay? So you need to consider what they do, what's the situation, and work with them. If there's absolutely no accommodation that's available, if I'm blind and I want to be a bus driver, there's nothing that we can do. So then at that point, you can go ahead and terminate. Yeah?
The accommodation the person would not like, would need at some point is for us to extend it 3 more months and then she gives birth. 3 more months. So she's already fully disabled because of pregnancy. When the FMLA finished, she's going to have 3 months.
3 more months, yeah. And that's what happened in this exact case. She went out for 4 months and the pregnancy wasn't over and she still was on bed rest. And they said, sorry, your leave's up, there's nothing we can do. If she comes back and says, well, I need an accommodation, I need to be out for another 4 months, 5 months, whatever the case may be, I don't know if that was reasonable. I don't know how many employees they had. I don't know what it was that she did. I don't know what their practice was. That's what you need to consider at that point. If you've got a large operation and someone says, I need an additional 3 months of leave, I'm fairly confident that the Department of Fair Employment and Housing would say that that's reasonable. But they're going to consider the particular nature of your business, and that's what you need to look at. Especially in the case of pregnancy, there have been big expansions in terms of the pregnancy or the protections for pregnant employees. So, if you're going to pick your battle, I probably wouldn't pick that one. But yeah, and at some point, just because the employee suggests something, hey, I want to be out for the rest of my pregnancy, and then I want to be out for another 6 weeks to bond with my baby, and then I want, just because they suggest it doesn't mean that the employer has to do it. Okay. You can come up, if there's a list of 5 possible accommodations, maybe the accommodation is, okay, you need to telecommute and you need to work at least, 5 hours a day or something. We get it that you can't stand up, but you can certainly do your laptop from your, room, whatever. If there's one accommodation that the employee really likes, okay, and there's one that the employer really likes, you can go with the one that the employer likes. You don't have to go with whatever that employee wants just because they want it. But you have to engage in that conversation to try and figure out what options are available. Okay. Was there another question back here? No? Okay. We had new guidance with respect to adult children, okay, and that's that, again, coverage under the FMLA. You can have time off to care for your children, okay, or a family member in need of, with a serious health condition. And the question came up, if I have an adult child that didn't get sick as a child but gets sick as an adult, does that count? And they said yes. It doesn't matter when the disability or the incapacity comes on. It just matters that they're not able to care for themselves, that they need you to come or the employee to come in and care for them, and so forth. So if you have an adult child, for example, who's in a car accident, okay, and they're disabled, they can't care for themselves, the employee needs time off to care for them, that's something that might be covered. Okay, if you have an adult child who has diabetes and is in a car accident, but they're still able to care for themselves, but they've had diabetes since they've been a little kid, so they're technically disabled, does that count? No, that would not trigger FMLA leave rights. Okay, so if you get the adult children issue, just be aware that there is new guidance out there. There's also new guidance out on the expansion of rights for veterans. Okay, they expanded, this is under the FMLA, those leave rights if you're a military service member, a caregiver of a military service member, or in the case of a qualifying exigency. They expanded that to allow for parental rights. That now it applies to veterans as well as active service members. And they qualified that a pre-existing condition that's exacerbated in the line of duty will also trigger those rights. There are new certification forms for those new qualifying exigency and caregiver leaves. Okay, so when somebody comes in and says, I need FMLA leave, you give them their rights and eligibility notice. This is what you're allowed to have under the FMLA. Here's the form. And they come back with their certification or their doctor's note or their reason, and then you fill out that designation form and you give them that. That certification that comes back, okay, there's a different certification if it's for the employee's own health problem. There's a different certification if it's for a family member's health. And now we're going to have new certification forms for qualifying exigency and military caregiver. Okay, I don't have those forms completed yet, but they will definitely be available in short order on our website. And just a quick little reminder on those forms when we talk about FMLA stuff. The medical certification forms, the Department of Labor, you'll get these emails. Hey, new form, pick it up and you download it from the Department of Labor. Great. Okay, those forms you can't use in California because there's information, there's questions on there that are against the law under the California Family Rights Act. Okay, they ask for medical information. So be real careful when you download those forms. CalChamber and their California resources that have forms that they've sort of taken that Department of Labor form and tailored it for California. Okay, so make sure you're only using those forms because employers get tripped up with that stuff.
Hey, this form you're talking about, is it what the employee would sign or what the doctor would sign?
It's the form that the employee would take to the doctor to sign.
Because with Kaiser, it seems like they just have, the doctor doesn't even sign it, it's just a pre-printed form. It's kind of the same for
Yeah.
you, your child.
Well, and that's one of the questions that the courts have looked at, not so much this past spring, but in the past. What do you do when the note says, Joe can't come to work, till whenever. That doesn't really tell you anything in terms of, does this qualify for a leave? Are they disabled? So at that point, and when you give them that eligibility notice, you should give them a copy of their job description. Okay, I don't know what your medical issue is or your family member's medical issue. These are the things you need to do. You come back with a note from the doctor that says, yes, I can and can't do that. And when that note is insufficient and you go back and ask them for a better note and you ask them for a better note and ask them for a better note, at some point you can declare that leave is not protected leave because they failed to meet their obligation to provide the certification that will give you enough information to make a decision as to whether or not it's actually a covered condition. So when they revised, in 2008, they revised the FMLA regulations altogether, big overhaul. And when they did that, they set up, this is what the employer has to do, and this is what the employee has to do. And they actually did put some obligation on the employee. One of those obligations is you need to come up with a certification that has enough information. And if they don't, then you can ask them for them and ask them. I wouldn't the day that the certification is due and they don't bring it to you, I don't think I'd fire them on that day. Okay, I'd give them a chance to fix it. But if they fail to provide the required paperwork, then that's not a protected leave. So, and I know of at least one case where that exact scenario happened. I can't think of the name of it, but anyway, the person did fire them, and they said, okay, well, if they didn't provide the certification, then too bad. Yeah. Are there other questions? That sort of a corollary issue there, if, we're talking about if they go to the EDD and they apply for unemployment benefits, I know the EDD takes the stance that it's not the employee's fault that the doctor wouldn't provide the information, so they might still be eligible for unemployment. But if you've got a person in there who's really gaming the system, they don't really need leave, they're having their brother-in-law who's a doctor write these notes, and it comes in, the day before they're supposed to come back to work and that sort of thing, you're better off to take a hard stance with them and get them out of there, because chances are they're going to, cause other problems, or they're just not a good performer. Okay. We have, with regards to that accommodation process, the Fair Employment Housing Commission set out sort of a revised regulations about that whole process. And it might be a good thing to look at if you're having issues, if people are coming in, hey, I'm disabled, or I need time off, or I'm so stressed, I'm going to take a leave. It walks you through that sort of accommodation process. Who needs to start it, who needs to suggest, this, how do they look at whether something's reasonable or not. They made some other little minor changes that, dogs can come to work and things like that. But it's a good review of that process. If you have questions, that's a good starting point. Okay, I want to jump into technology, unless there's other leave questions. Betty Page, this is, I don't know if anybody knows about Betty Page. They have all these like 50s clothes, whatever, it's a cute little store. But this was the store in San Francisco. It's in the Haight-Ashbury district. And the employees asked the store manager if the store could close an hour early because it was closing at 8 and they were leaving and there were street people around that were harassing them. And they felt scared and so forth. Store manager says, well, I'll talk to our corporate office, but she never did anything. Okay, so they get mad. They have this fight with the manager and they go online, like they all do, managers and you know what, and this place sucks and blah, 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 and all this horrible stuff about the store, about the manager. One of the employees who's having this Facebook fight says, my mom's friends, whoever is an employment lawyer, and I'm going to bring in a workers' rights book, and they can't do this to us. They can't treat us this way. Okay, so the big fight, another coworker sees it, tells the manager. 6 days later, all 3 people who were in that Facebook fight or discussion were fired. Okay, here comes the NLRB, Ooh, they love this stuff. They said no, those discussions were protected concerted activity to further better working conditions. Again, that's a protection that falls under the National Labor Relations Act. Okay, applies to all employers, whether you have a union or not. Though, because that conversation was in furtherance of better working conditions, it's protected. You don't get to discipline them for that conversation. Okay, so they were ordered to be reinstated. They got back pay. Okay, this was sort of a classic example of when you don't want to fire somebody for what they're saying online. Okay, when there's comments about the workers' rights booklet and I'm gonna, make sure we're getting treated fairly, that kind of stuff. That's sort of what the NLRB terms the sort of classic concerted protected activity. So not a good place, again, to make a stand. Bland v. Roberts, this was a sheriff's election, and the employees liked the opposing candidate, okay, and then they got fired for it. And they said, when I click my Facebook like, that is protected free speech. I'm allowed to endorse whichever candidate I want. And the court said, no, a Facebook like, just clicking a button, is not tantamount to speech. Okay, and so it doesn't trigger those protections. Not a California case, but a really good case for employers who, down the road may want to argue that, look, just these little comments online, clicking and so forth, doesn't count as speech. It's another way to sort of get at that online activity. I'm going to skip down. SkinSmart is kind of a funny one. She got mad at the employer and wrote all this stuff online. Go ahead, fire me, make my day, And so they did, and then of course she sued. I didn't really want to be fired, and the NLRB said, nope, that was boasting and griping, and you can fire her, And the employer's argument was we did exactly what she wanted to do. If she's talking about better working conditions, well, we followed her directive and did precisely what she asked us to do. So anyway, that was an example where the NLRB said this conversation, this discussion is not protected activity. Okay. They tend to draw a line between what they call boasting, griping, versus actually, trying to get employees to create a better work environment. Sometimes I think that line is pretty hard to draw based on some of the decisions that they've issued, but that's where they seem to be drawing the line. Okay, so for whatever help that is going forward. In the news stuff, one of the things that we're seeing a lot of are issues where employees are stealing information, data, trade secrets, because it's so easy to do now. Okay, a lot of people use cloud storage. Okay, so when they bring their stuff in, they store it all in the cloud. You may not even realize that those customer lists and sales orders and research is all getting stored somewhere up in the sky for them to go to the new employer and pull it all down and print it all out and give it to your competitor. Okay, so you may want to look into data security. There's lots of software and things that can kind of help to limit some of those downloads. There's also, web-based programs like Dropbox where you can just take the information, load it on the web, and then you leave and so forth. So you may want to consider tightening up that those trade secret protections, in your handbook, and whether it's investing in technology to help stop some of that. But that's becoming a much bigger problem. On the top of the next page, the social media password law. This was a new one that came into effect January 1 of this year, and it basically says when somebody comes in to apply for a job, you can't say you need to give me your Facebook password, you need to give me your MySpace password, you need to access your password or your account while I look over your shoulder and see what's on there. Okay, they said it's illegal to force them to divulge social media information. What we're seeing now is what happens when a supervisor sends a friend request to an employee, okay, and that employee friend says accept, okay, because I felt like I should because that's my supervisor. I don't want to say no. Well, now that supervisor has access to all of that social media information that they weren't supposed to have access to, okay? Now they've divulged all of their social media information to that employer. Okay, it's a little bit of a conflict, and we'll have to see how this stuff plays out, but those tend to be some of the issues that are coming up. It's a great example of why, at least for your supervisors, for your top level people, okay, to friend or not to friend is not to friend, okay? Do not, I really can't even stress that strongly enough. The problems that we have where, whether it's, harassment issues, whether it's, just bad stuff, okay, online. You don't want to mix those two worlds, all right? And an easy way to explain that to your employees is that, look, when you friend everybody underneath you, okay, and then somebody from college posts some raunchy picture on your Facebook page, and we end up with a harassment suit, it's going to get filed against you, okay? It's not just going to get filed against the company. So this is potentially something that can really protect the actual employee themselves. Okay, and that can be a big selling point when they realize that there's personal liability for this stuff potentially. But anyway, that's a new one. Just really, and you can't outlaw it. You can't tell people you don't get to be Facebook friends with people online or people that you work with. But as much as you can discourage that stuff as possible. BYOD, bring your own device. I have a lot of employers that have opted to give an allowance for cell phone or tablet or iPad or whatever you're going to use, as opposed to actually providing that. If you're doing that, just be really careful. Be really mindful of the fact that that's going to limit the access you have to that device. Okay? There's going to be greater privacy protections for that employee. Also, gives them a lot more latitude in terms of, taking information and storing it elsewhere. So just some things to consider. All right. I'm going to move into discrimination and harassment and retaliation, all that good juicy stuff. Harris v. Santa Monica, City of Santa Monica was a big case we've been waiting for. It came out of the California Supreme Court recently, and what they were looking at is whether or not you can have a mixed motive defense under the Fair Employment and Housing Act. And what a mixed motive defense is that, okay, I fired, Jill. Okay, I fired her because, I hate women, so that was part of the reason. But I also fired her because she's this horrible employee and she didn't show up 4 days in a row. Okay, where you have an employment decision that's based on a bad reason, but also based on a good reason, is that going to be a defense? And the court said yes, under the Fair Employment and Housing Act, and if the employee shows, look, this discriminatory reason was a substantial factor as to why I got fired, as long as the employer can come up with a legitimate, non-discriminatory reason why they took that action, they're going to be okay. Okay, it was a big win for California employers, and it was a 6-0 decision, so there seems to be a lot of weight behind that. The next one, Hatay v. Department of Transportation, talks about Me Too evidence. And Me Too evidence has been something I've really sort of been harping on with my clients because I think it presents a lot of big issues. And the idea of Me Too evidence is somebody files a lawsuit, okay, and then they want to bring in support of their lawsuit, hey, that happened to me too, and me too, and me too, testimony from all sorts of other employees that were similarly situated that experienced the same thing. Okay, we had a local attorney in Bakersfield who got hit with a harassment suit. He won at the trial level. It goes up on appeal, and on appeal they say, hey, we're going to let in all this Me Too evidence. Every other female in the office who says he ever said a bad word or did whatever, all of a sudden gets to come in and bring all this evidence in, and then he loses on appeal. Okay, so it was a really bad case. I think it was bad logic and very potentially dangerous for employers. In this case, we saw a little bit of a limiting of that. This was a discrimination case. The plaintiff was Japanese, and he says, hey, I didn't get promoted because I was Japanese. My supervisor is an Arab, and he only promotes Arabs. Okay, and when the case went all the way up, they said, well, you're saying you were discriminated against because you're Japanese, so you can only bring in testimony from other Japanese people who were also discriminated against. He wanted to bring in testimony from everybody else in the office who also wasn't Arab and also didn't get promoted. Okay, and they said that's too broad. So they kind of hemmed it in a little bit. Again, though, that Me Too stuff is really, really scary because you imagine that every bad comment, has now been memorialized. It's an email, and it's in a text, and it's on Facebook, and you can print it out, and it floats in the air until somebody wants to get it. If all of that information comes in, what seems like a couple of sort of innocuous comments can all of a sudden, get built up into this huge mountain of evidence. So be very, very careful about what you say, and certainly about what you put in writing. In the workplace. Hollingsworth v. Perry, I'm going to sort of skip over. That's the big California same-sex marriage is legal in California, but I'm going to wait until we talk to its sort of companion case, which was that Defense of Marriage Act case. That's on the next page, I think. Yeah. So Sanchez v. Swissport. This was the case. Where, okay, when the leave ends, you don't get to just immediately, terminate the person, okay? There are leave obligations that are part of that interactive dialogue process, okay? Not necessarily that you have to grant the leave, but you just have to have that discussion with them, okay? It kind of dovetails on what we were talking about earlier with regard to your person who was out on pregnancy and wanted to stay, wanted to stay out on leave. Nassar is another big one that we had, and this was from the U.S. Supreme Court. Okay, and they're talking about but-for causation when it comes to retaliation claims. And when when somebody brings a retaliation claim, okay, we're back to that sort of mixed motive. Well, yeah, we didn't like them because they were Greek, but we also didn't like, the way they performed. They had bad evaluations, they'd been counseled and so forth. Okay, and what the court says here, and they sort of went along with a line of cases that has been established with regard to age discrimination, is that the plaintiff needs to show that that bad action on the part of the employer would not have happened but for the bad motive by the employer. It's a very high causation standard. Okay, as long as, they have to show that the only reason why this happened to me is because I'm, a woman, or I'm old, or I'm Muslim, or I'm whatever protected category they're falling into. Okay, and unless the statute specifically says, if this discriminatory intent is a motivating factor, then we're going to use this higher standard. Okay, a great case for employers, and it kind of dovetails nicely with our Harris case that we had. So I feel like, you sort of have the courts, they swing as far as they can out into the world of crazy decisions, and then they finally start to come back in. And I think that's what we're really starting to see. These crazy discrimination cases and rulings are finally trying to get hemmed in to a place that's a little more reasonable and manageable. So that's what the employee needs to show. They need to show but-for causation when they bring a retaliation claim. Again, this is under Title VII, okay, which is a federal law, but still helpful for California employers, since we have to comply with federal law as well. U.S. v. Windsor. Okay, so this is the big same-sex case, all right, the Defense of Marriage Act that was struck down, I don't know, a month ago, a couple weeks ago. And what the court basically said, they looked at that Defense of Marriage law, and this came about because there was a woman who'd been married in New York when same-sex marriage was deemed legal in New York. Okay, so she gets married, her same-sex spouse dies, and the federal government would not recognize that marriage, so she ended up getting an estate tax bill of like $300,000. Okay, so she sues, and that's how this case came up to the Supreme Court. What they said was the law is fine, everything looks good, except for it's unconstitutional for you to define a marriage as between one man and one woman. Okay, so that's Section 3, they struck that out, the rest of it's okay, fine and good. When they left the rest of it as fine and good, they left in Section 2, which says, okay, each state can decide for itself whether or not it wants to permit same-sex marriage. Okay, and if you don't permit same-sex marriage, you don't have to recognize same-sex marriage of other states. Okay, so for everybody in California where you have multi-state operations, this creates a problem, because what if you have somebody who, lives and works in a state that does have same-sex marriage, but, or gets married, I guess, in a state where there is same-sex marriage, but then goes to work in a state where they don't recognize it? What are you going to have to do for those people? And that's another issue that's going to, I'm sure, get litigated in the fairly near future. At any rate, when you couple that decision with the Hollingsworth case, we have same-sex marriage in California. Okay, so all of those spousal benefits, whether they're benefits in the, tax benefits through the Internal Revenue Code, whether they're FMLA benefits, leave rights for spouses, whether it's something in your handbook policy that says, bereavement leave for your spouse, all of those things are going to apply to same-sex spouses as well. Okay, probably less of an impact from a cost standpoint for us in California because we've had those protections for domestic partners as well. But just, be careful that you don't get tripped up with, okay, well, we need to see your marriage certificate. Make sure you're doing that for, men and women that are married, as opposed, not just for the same-sex people. We don't want to treat people differently. We just make sure you go back through those benefits and make sure that everything's extended to the same-sex couples as well. Vance v. Ball State looked at the definition of a supervisor. Okay, I do have this theory that we're going to litigate, every single word of the labor code. So this was the U.S. Supreme Court trying to define what is a supervisor, and to the surprise of many people, they went with a more narrow definition. It's somebody who's empowered to actually take employment actions against somebody. That's hire, fire, transfer, terminate, whatever, the change benefits, things like that. Okay, under federal law, if you just direct the day-to-day activities of somebody, you're not going to qualify as a supervisor. It's, of limited help for us in California because our Fair Employment and Housing Act does include language that says if you direct the activities of another, you're going to be considered a supervisor. But at least it opens the door for some of those. And a lot of the federal laws, when we talk about liability that gets imputed onto the employer, okay, it's actions on that a supervisor is taking. So that's where that's going to become critical for us. At any rate, a good case in the sense that they didn't adopt that, and had they adopted that giant definition of supervisor, we would have been training everyone, for sexual harassment training also. I'm going to move on the top of the next page, that Westendorf. This is a good example. It's sometimes hard to decide what is a hostile work environment. Okay, the court looked at this situation and said that's not a hostile work environment. Okay, and so that gives us a little bit of guidance. It's a Ninth Circuit decision, but nevertheless, it gives us a little bit of a framework. There were 4 sexual comments that were made. The supervisor overheard, joined in, laughed, didn't stop the conduct. But the court said those 4 comments over, I think it was a period of like 6 months or something, were not enough to create a severe and pervasive environment that altered work conditions. So they didn't decide that the whole case goes away because they said, well, she might have been retaliated against because she was later fired. So she might have been, the retaliation claim goes forward, but at least to give us a picture of what a hostile work environment is, what does severe and pervasive mean? Those are those terms that have been pretty difficult for employers to define. So that was a good case in that regard. Winston v. Countrywide. This was a reversal of a $3 million jury verdict, and it's an interesting case because we have that theory of, it's called the cat's paw, okay? And the cat's paw doctrine is if you have a supervisor who has all of this discriminatory bad intent, I hate women, I hate, whatever group. This person with all this bad intent, and then here you have the hire or the decision maker, the person who's hiring or firing, and they're a separate person, okay? But they're influenced by that supervisor with a bad intent. You can use what's called the cat's paw. You reach around, grab the bad intent from this supervisor and bring it over to the decision maker, okay? And there can be liability based on that. In this case, okay, it was a company that was acquiring another company. When they acquired that other company, they decided we don't need the HR director anymore. Okay, and who's better equipped to sue than the HR director, who knows all the HR laws? Yes. The HR director sues and says, look, I know the reason why I wasn't kept on, and it's because, last year at my old job, I filed an OSHA complaint. And you know that I filed the OSHA complaint, and that's why you chose not to keep me. Well, it turns out the person who knew that the OSHA complaint had been filed was not the same person who made the decision as to whether or not to keep that person on. There was a division between the person who saw the personnel files and knew everything and the person who made that actual decision. And that division is what saved that employer. That they ended up losing. They said, nope, there's no liability. They had no reason to know that you'd filed this complaint. There's no reason to impute that knowledge to them because there was no interaction between those two. Okay, it's a really good lesson. If you've got people that have been involved in a harassment issue or something, or you have reason to believe that one person might have an issue with the other person, okay, insulate that bad motive from the final decision maker, okay, because that can be a really good and useful defense. We have new mental disorders, mild neurocognitive disorder, and a social pragmatic communication disorder. Why do we care about new disorders? Because, again, those are things that may trigger that accommodation obligation. Okay, a little bit scary, especially that mild neurocognitive disorder is a modest decline in learning or memory. Okay, so pretty much everyone that I know has mild neurocognitive. But these are, if you're disciplining somebody for poor performance, hey, you never listen. Oh, well, there may be additional interactive dialogue, accommodation obligations that you're going to have to go through. So that came out about a month ago, so get ready for those. EEOC had more than $365.4 million dollars that it secured. These are, again, this is discrimination claim. That's in addition to the labor commissioner does the wage and hour stuff. We have the cases that settle because they don't even make it to the administrative hearing level or the trial level. This is just the discrimination side. You can start to see a picture of how much money actually changes hands. So it's really important to stay on top of this. We had our first genetic information discrimination claim that was filed, and it resulted in a $50,000 settlement. She was asked about her family medical history for their wellness program. It was done as part of her post-offer, whatever, paperwork and stuff. They rescinded the offer, and she said, oh, I know why you rescinded it. You rescinded it because I wrote down all this stuff about my family medical history. They said no, they rescinded it for other reasons. At any rate, it didn't go to a trial, but it settled for $50,000. So just be careful. When you give that offer, okay, make sure you're giving it to somebody that you want to actually, come and work. And do that homework before, because you run into trouble when you try to rescind that after the fact. We got some guidance with respect to internal investigations and the employer's ability to keep those investigations confidential. This was a memo that the NLRB just published in April, but what it says is, it starts from the premise that if your handbook says you're not allowed to talk about anything that happens in an investigation, you have to keep everything confidential, they assume that that violates that ability to discuss and talk about work conditions and so forth. So they start from the premise that that's illegal. What he outlines in this memo, though, is a way to sort of get around that. It's kind of this magic language that says, look, we have a legitimate and important interest in keeping people safe from retaliation and so forth. As such, we try and keep these in strict confidence, and we're going to impose that reasonable limitation on you. If you're involved in an investigation, you need to keep it in confidence. Okay? He at the end of this memo says, well, if it said that, then it would be fine. So what I want you to do, go back to your handbook, okay? Let's put in that magic language, instead of saying you need to keep employee investigations confidential, I want it to say, this is our legitimate reason that we're compelling interest, we're trying to protect, and blah, 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 because I don't want it to be subject to scrutiny on that grounds, okay? And actually, in that bullet point, it talks about the language that you're going to want to include there. Health and safety, $5 billion in settlements for whistleblower claims. I mean, the money just is sort of staggering. Actually, what's not on here that I could have added for the whistleblower stuff was probably the biggest whistleblower case of our time was Enron. And Jeff Skilling, who was the CEO of Enron, just got his prison sentence reduced from 24 years down to 14. So that's sort of newsworthy. And I was at the time thinking that doesn't seem very fair, although the alleged mastermind behind all of their crazy accounting was a man named Andrew Fastow. And Andrew Fastow last month was the keynote speaker in Vegas at the federal audit examiners conference. And I thought, really? That's crazy. But I just want to run into the termination stuff quickly. KCV, the Humane Association or Humane Society, is an interesting one. She worked for the Humane Society or Humane Association, and she complained about animal cruelty. The Humane Association was working with HBO and producers there. They were producing a TV or a show called Luck. I don't know if any of you ever watched it, but anyway, apparently they canceled the show because 4 of the horses that they were using as the production ended up dying. And so she complained about animal cruelty and so forth, and she gets fired. Okay, and so she brings a lawsuit against her employer, but also against HBO and against the show producers. And she says, look, they assisted and encouraged in me getting fired, and so they're part of this wrongful termination suit. And the court said no. There's no, aiding and abetting claim for wrongful termination. So the suit's still going to proceed against her actual employer, but they kicked HBO out and kicked the producers out. O'Brien, which is the next one, was a first grade teacher who posted on Facebook, I'm not a teacher, I'm a warden for future criminals. Great idea. So she got fired, and the court said that's fine. She said this is free speech. I'm allowed to make comments about, issues that I see in the workplace, and they said no, your free speech rights are outweighed by the school's interest in protecting the students and so forth. Not a California case, again, but you're starting to see sort of that crunch on the speech rights of employees, particularly when we're talking about social media, where that stuff goes out to a broad range of people. Nicolette Sheridan is getting a new trial date. For those of you who watched Desperate Housewives, we followed this all the way through. She had her trial. And then that was a hung jury. It was 8-4 in her favor, and then they kicked her claim out, and then she wasn't going to get to sue at all, and then she appealed that. And now they've said, yes, you get to go forward. So it's like it's more dramatic than the stupid show that she was actually written off of. But at any rate, so we'll be able to watch and see what happens with her. So that's it for termination. Are there more questions about this stuff? It's a lot of information. I realize your eyes are glazing over. Arbitration agreements, and I joke that this section should be called, big mess. Who knows? It's all over the map. That we've had a lot of really sort of significant cases that have come down. The problem is they're coming from the U.S. Supreme Court, from the federal side, and on the state law side, these issues are still way up in the air. Okay, questions about whether or not in an employment context can we enforce an arbitration agreement if the employee is required to sign it as part of, it's mandatory that they sign it. There was a case in here, SERPA, it's on the, there's no page numbers at any rate, it's the last case before the pending cases. He argued, hey, the arbitration provision is in the employee handbook, and the employee handbook says the employer has the right to modify and change these policies whenever they want in their sole discretion. So there isn't really a promise to arbitrate because they could change that at any time, with or without notice to the employee. Most handbooks contain a paragraph just like that, allowing the employer the right to revise. Okay. If you've also got an arbitration provision in there, that was the question, does that negate that arbitration provision? Court said no, that's okay. We're going to imply a duty of good faith and fair dealing. That's not going to negate the arbitration provision. But it just shows you sort of the slant of the courts. There's really arbitration tends to be really disfavored in the state courts and really favored in the federal courts. The other issue that comes up a lot are these class waivers. If you have an arbitration agreement that says you need to bring all of your claims individually, you cannot bring a class action. Okay, whether or not that's going to get enforced is at issue right now. And there's a case pending before the California Supreme Court that's going to probably answer that question. What I would encourage you to do, if you do have arbitration agreements or provisions, put that class waiver language in there. Because if the California Supreme Court says class waivers are good, you can knock out a Private Attorney General Act claim, or however that case comes down, you're going to want to have that language in there. Okay? It's not going to be effective if you've already given the employee the stuff, they've signed off on it, and then 2 weeks later you change it and don't tell them. This is something you're probably going to want to put in and do as part of your handbook update, and so forth. It's just something to get on your radar screen. It's certainly language that at this point isn't going to hurt you, and better to have it in than to not have it in. Okay, we have enough cases that say, yeah, class action waivers are going to be upheld, that putting that language in probably is not going to negate the agreement as a whole. That was typically the worry, so that's why everybody took them out. Now we're saying put them back in. Now I'll come back in January and say take it out. But for now, that's where we're at. Okay, and then I'm not going to go through the class action issues because that's this more procedural issue. The big picture is that the courts are really down on class actions, particularly the federal courts. We're seeing a lot of cases that are not being certified. If you have to use statistical evidence or if you have to use experts, they're saying this isn't appropriate. And so that's some welcome relief for all of us that have been trying to, navigate those. All right, it's a lot of stuff. I usually try to find something that's sort of funny or entertaining, but there just was a really dry spring, apparently. So my apologies. Hopefully January will be a little better. At any rate, questions? And I'm happy to stay after. Just let me know if you want a copy of the January update. All right.